Hi guys, AJ here and welcome back to LAWS14006, Legal Risk Evaluation and Systems. And this week we are in week 6. Wow, halfway through the unit, hasn't time flown? This week we are going to be looking at legislative and regulatory risk and the whole compliance exercise. This is chapter 4 of the text. And in that chapter, you will get the feeling that Wayne and Gazzellian convey this as an inordinately complicated risk area, and I would have to agree with that assessment. Legislative and regulatory compliance really is an exercise that is becoming increasingly specialised because of the increasing amount of legislation and regulation that organisations need to deal with. You've only got to look at the realities of trading nowadays. You have not just the legislation and regulations that apply in your own location that you need to be worried about, but increasingly, organisations are dealing statewide, nationwide, and globally. So you're looking at the whole issue of finding out what regulations, what legislation applies statewide on a nationwide basis and increasingly globally. So if you have a look at the video that I've got on the panel discussion, the lady from Vodafone was saying that they need to comply with approximately 80 different jurisdictions worth of legislation. So you can tell, that kind of exercise is going to require not just a dedicated compliance department, but I would hazard a guess, a number of different such departments operating globally and interacting to make sure that the company got it right. Apparently there's approximately 320 odd legal jurisdictions worldwide. So, Vodafone's looking at having to comply with approximately 25% of the world's legislation. And it's not just on areas that you might immediately think of when you're thinking about regulating the communications industry. So the whole ICT bundle of legislation, but you're also looking at, she mentions things like having to source minerals for the components that go into the handsets. You've got a whole heap of environmental legislation there that comes into play. So it can be a huge exercise that you need to get your head around. The other thing that makes it more complex again is the issue of tiering and layering. So you've not just got, for example, in Australia, your own local state legislation on point. You may have federal legislation that's also on point. There's the same kind of setup in the United States. So they have state legislation, they have federal legislation. So this, and often you'll have local regulations as well. And in countries like China, it can be very difficult to work out which of the local regulations, which of the state regulations, which of the countrywide, nationwide regulations apply, and how they apply, and how they all interact with each other. So that's tiering, layering. Obviously with global operations, you've got your country's legislation you've got to be worried about. You've got the incoming or outgoing country's legislation you need to be worried about. So if you're doing a deal with the UK, a UK distributor, which law is going to govern your contract? If you choose a particular jurisdiction, what are the laws in that jurisdiction? What is the regulatory agency that you're going to have to be interacting with? If you're looking at a retail agreement with someone in the US, again, which law is going to apply? Why should that law apply? And what is that law all about? What does it require of you? So tiering and layering really make this exercise quite a large one. And you'll find that compliance departments are, popping up in many different organisations now, just because they need to pretty much be full-time on the whole horizon scanning exercise, capturing the laws and regulations that apply, documenting them all in order that a sufficient and adequate response can be made by the organisation to those requirements. So what are the policies that have to be put in place? What are the procedures that have to be put in place? So if your company or organisation is not quite so large to be able to support a compliance department, you might find that they undertake the exercise in-house, or they might farm it out to an external lawyer. They might have a panel of external lawyers, and external lawyers will be particularly useful where you are operating globally and you need to know what the laws and regulations are in other overseas jurisdictions, for example, like China, where you've got the difficulty of not only finding the legislation, but trying to find an English translation of the regulation. There's a lot of non-reporting that goes on in China, so you don't have an easy database to consult in order to find legal decisions that interpret the laws or regulations that you're concerned with. So it's really only going to be those overseas law firms that have a base locally that can chase up the relevant laws and regulations for you and chase up the relevant decisions that interpret those laws for you. So that is a little bit of a snapshot of the whole legislative and regulatory compliance exercise. In terms of the text for this week, I just wanted to make a couple of comments on a few things that they talk about in this chapter. And firstly, they go through the exercise, another scenario matrix, on working out the cost of compliance. Now, this can be a useful exercise. However, if, for example, you are an organisation like CQU, then you'll see in their risk appetite or risk profile, they actually have specified that legislative and regulatory compliance failures have a zero tolerance. So the organisation will not accept any risk of compliance failure. So in that kind of situation, it's kind of pointless to go through the whole exercise of working out what it's going to cost to comply, because CQU has already said, well, it doesn't really matter what it costs, we have to comply. Similarly, Whaley and Gazzellian go through the consequence of non-compliance. I understand that many organisations do go through these kinds of calculations. How bad can it get if we don't comply? But again, organisations like CQU, they've said, sorry, we have to comply. We have a zero risk appetite for regulatory failure, compliance failure. So it doesn't really matter how bad the consequences are, how light the consequences might be for non-compliance. We just won't accept non-compliance. So again, an exercise that can be useful, but you really need to consult the organisation's risk profile or risk appetite before you do these kinds of things, because it may well be that they have a zero risk tolerance for this kind of thing anyway. Whaley and Gazzellian also talk about time, and I guess this is a useful point to keep kind of in the back of your mind somewhere. When you are doing a compliance audit or update the company's compliance manual, or you're doing one for the first time, it can be useful to work out, well, what is the time horizon we've got to play with here? How long do we have to put our measures into place before we're going to be subject to some kind of surveillance by the regulatory authority? Usually you will find when there is any significant change in the law, that change will always be ushered in an appropriate manner. So, it won't just be lumped on everybody and commence, and then, no one has any forewarning and everyone's madly panicking to get their compliance systems in place. Usually you'll find there'll be some kind of staged implementation, or there'll be a reasonable multi-year time horizon for the change to come into effect. So keeping one eye on the timeframes required can help you prioritise which of the compliance risks that you need to address more quickly than perhaps others that have a longer time period allowed for implementation of compliance measures. Whale and Gazillion also go through things like, the typical in-house compliance department. I'll leave you to go through that there. They also go through, the effective structure and operations of organisation's legal department. Again, I'll leave you to explore that at your leisure. But perhaps one thing that Whale and Gazillion don't go into in a whole lot of detail in this chapter is the softer side of the whole compliance exercise. Perhaps because they are very focused on what can be put on paper and how can we document our compliance system so that if we are subject to surveillance by the regulatory authority, we're going to have all our documentation in place to satisfy their requirements and their needs to know that we're doing the right thing. What we have in the regulatory authorities is an increasing focus on the corporate culture. What kind of culture is it that is operating within your organisation or within your firm? Because that is very likely the thing that's going to dictate whether or not your compliance manual is effective. I mean, it's one thing to have a very nicely executed compliance exercise where, the legal and regulatory requirements have all been captured and put into a nice database, and then they've all been analysed and evaluated. There's been decisions made as to what kind of controls the company needs to put in place in order to satisfy those legislative requirements. It's all then packaged up and tied with a neat bow. That's not going to satisfy a regulator if that little package has then been placed in the bottom drawer and, the people that are going about their jobs at the coalface really have no knowledge and do not implement that compliance manual, okay? The regulators are really starting to focus on what is happening at the coalface. They don't want organisations to engage in this tick-the-box mentality where, the C-suite has sat down, they've said, we need to be compliant because otherwise, look at this other organisation, they've had some scary fines imposed because they didn't have a compliance manual. Let's do the exercise, let's do the compliance manual, and then that's it. Regulators want to see that compliance manual being put into place as a living, breathing document that guides decision making on a daily basis, okay? And not only the compliance manual, but kind of the fluffy stuff that floats underneath that, the kinds of attitudes that the organisation encourages to doing the right thing, implementing the compliance manual, but more than that, doing a good job, doing the right thing, and particularly doing the right thing in the financial services industry so far as your customer is concerned. Okay, I found a couple of nice little articles that might be of use for you, and we'll have a little look at them now. Okay, so here we can see I've got a nice little article here called The Culture of Compliance. A couple of years old, but it's pretty good. It mentions a few legal decisions that are useful in understanding this aspect of compliance. It alerts the reader to the fact that regulators like ASIC and also increasingly the ACCC are quite concerned with the idea of culture, because it really is the driving force behind behaviour, and of course, compliance is squarely concerned with issues of behaviour, the kinds of actions that are taken, the kinds of decisions that are made. In particular, I guess you might have seen this decision before in your corporate and commercial studies in your degree program. The ACCC and Visi case is a really nice little example of just how important culture is and how badly things can go wrong when an organisation's culture does not line up with its compliance policies and procedures. And there you had Visi and Amcor, both big boys in the game of cardboard box manufacture. And they had engaged in price fixing and market sharing, so cartel behaviour, which is obviously contrary to the Competition and Consumer Act. And we had the executives, so the very top level directors in both Visi and Amcor engaging in this rather flagrant conduct, late night phone calls, late night meetings in all sorts of dodgy venues to discuss and agree their naughty plan to take over the market in the cardboard box industry. So we had this culture of, we don't care what the law says, we don't care what our compliance manual says, we're just going to do whatever suits us to get ahead in this particular market and make it our own. And so you had a fine ultimately, and bear in mind this is 10 years ago, so a fair bit, $36 million imposed on Visi, and we had fines for the individual directors involved as well. Have a look here though, this is rather delicious, and for our purposes the most relevant part of the decision. The judge noted that they had a compliance manual, but it might as well have been written in Sanskrit because nobody took any notice of it. And that was very, very clearly established by the fact that from the top down, so from these naughty directors, and one of them was, the founding director of the company, from the top down, there was this attitude of, we'll just do what suits us, despite the fact that we have a compliance manual that sits in the bottom drawer there. So have a little look at this article if you have the time. It's certainly not prescribed, it's just an interest article for you. I'll put the link up here. And one other thing before I leave this is that the article does mention an Australian standard. Now that standard, even though this is only a couple of years old, that standard has actually been superseded now. If you want to have a look at the Australian standard for compliance systems, have a look on the CQU Library website, go to the database page, choose S for Standards Australia, and if you look at, if you type in 19600-2015, that is the new Australian standard for compliance systems. And one thing I think that is quite nice in this Australian standard is this visual depiction of the compliance management system. Now, it might kind of rattle the brain the first time you have a look at it, but actually when you read through it, it's not rocket science. It goes through the usual steps. So you got to look at external, internal issues. You've got to look at your stakeholders. Over the other side, the C-suite has to look at good governance principles. Your board has to be on the same page as the regulator in terms of a commitment to doing things well and doing things right in compliance with whatever regulatory regime is in place. If you want more on good governance, have a look at Chapter 2 of Whaley and Gazzelli, and they go through a nice little discussion of good corporate governance there. That all feeds into your actual exercise where you're designing your compliance system. First off, you're going to do a scoping exercise, and then you need to look at policy. Policy is the precursor, because policy is essentially the organisation saying, well, these are our attitudes and beliefs, these are our requirements, these are our aspirations towards compliance. Okay, then it drips down through the organisation, and it makes the chances of your whole compliance system becoming effective much more likely. Okay, then something similar to what we've looked at in terms of the whole risk assessment process. You've got to identify the relevant risks, and then you have this nice virtuous cycle that goes around here in terms of successive iterations, each time being tweaked, the compliance manual being tweaked to become more effective. So you've identified your risks, you've then got a plan to address those risks, you've then got to implement your controls, and you've got to get evaluated and monitored to see up here, number 10, what's going right, what's going wrong, how can we make it better, and then the whole thing starts again. Just harking back to what I said before, you can see in the middle there, that is the prime importance of the whole top-down attitude towards this process, okay? If you don't have the board's buy-in to this, if you don't have the executives in the C-suite wanting to do the right thing, wanting to be a good corporate citizen, wanting to protect their customers, then you stand fairly minimal chances of having any compliance manual actually implemented at the coalface where it really matters. The last thing I wanted to take you to was a speech, a couple of years old now, but still, by an ASIC representative. And look at this, the importance of culture to improving conduct in the financial industry. And it's another nice little resource for you to have a little explore of. Here's the link. And it goes through some rather useful reasons that set out why the regulators are so interested in culture nowadays. Obviously, there's some fairly large costs involved if you get your culture wrong, not only remediation costs, fines and so forth, but also your reputational costs. Have a look here, approximately $250 billion in costs that they're saying resulted from poor conduct in 10 global banks. Fairly scary figure. The one below is probably even more scary. The largest banks in Britain paid 60% of their profits because of poor conduct. And the argument that this speech makes is the poor conduct is really facilitated by the fact that the culture was just so wrong. The other thing that I like about this speech is just some of the snippets of things that a regulator will consider is a positive culture. Okay, all too often we say, oh, these are the things that went wrong. Look at that corporate culture, it was abysmal, and that's obviously why they had no compliance manual or compliance system, or that's why the compliance system like in Visi was just ignored. So we have things like positive culture being, looking after the long-term interests of your customers, looking at the whole product design process, looking at how appropriate the products and services are for your customers that you're selling to, looking at controls in place to support culture, okay? And obviously things like training, rewards, and all of that, those kinds of components should be built into your compliance system. So there are just a couple of extra little resources in case you'd like to paddle about in this area. And that's about it from me. If you have any problems or queries in relation to what we've talked about today, send me an email or post something in the forums. Other than that, I look forward to chatting with you sometime soon in a Zoom. And thanks for watching. Bye, guys.